Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Most criminal trials don't require experts. In most criminal trials, the testimony goes something like this. They put the clerk from the convenience store on the stand and they say, "Were you working on July 3rd? Yes. And what happened on July 3rd? Well, the store was robbed. When you were robbed, do you recall seeing the face of the person who robbed you? Yes, I do. Do you see that person in the courtroom today? Yes, I do. He's sitting over there at the defense table." No further questions, basically. That's what the witnesses do in your garden variety criminal trial. They come in, they testify about what they saw, what they smelled, what they heard, what they did. They don't talk about their opinions about any of that. They talk about what actually happened. Unless the defense makes an expert either necessary or they bring in one in the defense side. And when they bring in an expert, generally speaking, it's somebody who is a psychiatrist or a medical doctor, somebody like a pathologist to dispute autopsy findings and that sort of thing. They don't usually involve experts that are experts in engineering or other things of that nature. They sometimes do, but it's fairly rare. But you know where those things really show up a lot is in civil litigation. So when the bridge that was collapsed in Baltimore, when it was hit by the boat, when those lawsuits go to trial, there'll be lots of engineering experts, there'll be maritime experts, there'll be navigation experts, there'll be safety experts, there'll be every kind of expert you can imagine, and they'll be on both sides of that case. So one of the things that civil litigation attorneys, both on the plaintiff side and on the defense side, learn to do is file a Daubert motion. Now, I've had several issues come up in cases with regard to Daubert, and I believe I've done a video here on the channel that deals with Daubert. But Daubert is the Supreme Court case, the U.S. Supreme Court case, that essentially sets the standards for expert witnesses. And there are certain things you have to establish in order to have a witness testify as an expert. Now, most of the time when we're doing this, we're talking about science and engineering and psychology and medicine and that sort of thing, but it doesn't have to be that way. For example, it's perfectly appropriate to have an over-the-road truck driver talk about highway design and about why something would be unsafe. One of the things that defense attorneys have been really good at is suppressing expert testimony that they don't like. Most of the time when they do that, they follow a predictable pattern. This is the expert. This is why he's unqualified. This is why the court should rule in our favor and suppress all of his testimony. That's gross oversimplification, but generally speaking, that's the approach. And the reason that's the approach is because it continues to work. And the Supreme Court, and of course the Supreme Courts of the many states, have not shown any desire to back away from the sort of hard and fast rules of the Daubert opinion. The reason I point that out is that I was sort of critical of the fact that there are civil litigators, more or less, litigating on behalf of Alec Baldwin in the Alec Baldwin shooting trial. Somebody did point out that I had missed in the long list of their specialty areas that there was a category for investigations, and then at the very bottom of that it said white-collar criminal defense. I missed that when I looked at it. But there is a big difference between white-collar criminal defense, which usually involves paperwork, it usually involves fraud and that sort of thing, and it doesn't usually involve firearms or death or that sort of thing. So there's a big difference in terms of the types of information, the types of testimony that you put on in those cases as opposed to something like the Baldwin trial. And I just figured maybe they weren't up to the task. And then I started looking at some of these motions. So this first motion that we're going to look at is a motion in limine to preclude improper opinion testimony from Alessandro Pieta. Now you may be wondering why that name, Pieta, sounds familiar. Well, it's because Pieta is the person who designed and built some of those firearms. And there really couldn't be anybody more qualified to talk about the design and functionality of that particular firearm than Alessandro Pieta. But a well-drafted Daubert motion or motion in limine like this is designed to make Alessandro Pieta look as though he has never had so much as a cap gun in his life, that he wouldn't know what to do with it if he did have it, and we don't even know why he's testifying because he doesn't have anything to say. In essence, almost all Daubert motions devolve to this.
I love to dance a little sidestep.
So this is an old trick, and one of the things you'll notice that we're talking about having this filed on June 24th, so roughly a little more than a week out from, actually, I guess more closer to 2 weeks out from the actual trial. And the reason these motions are filed so close to the deadline is because you don't want to give the other side any opportunity whatsoever to reply to these. You basically want to hamstring them in their efforts by making them work harder. It's sort of like what George Patton said about nobody ever won a war by dying for his country. He won a war by making the other guy die for his country. And that's sort of what the rule is here. You make them respond to your motions. You don't respond to their motions. You make them come to you. And that's what these motions are all about. Now, first of all, they say we want to preclude him from offering improper testimony and opinion. Well, opinion is only improper if it is not helpful to the jury and if the person offering it is not qualified. So they say the state disclosed it intended to call him as an expert in the area of manufacturing of the Pieta replica revolvers and the manufacturing and functionality of the Pieta revolver used by Mr. Baldwin. Now, they don't go on ahead and finish that sentence and say to kill Helena Hutchins, but they probably should have. Mr. Pieta is one of 5 purported firearms experts disclosed by the state. As the name suggests, the revolver used by Baldwin on the set of Rust was a Pieta revolver, produced in Italy by Pieta's company. But Pieta has no knowledge of the gun's physical condition other than what is contained in company records of its manufacturing and testing in Italy. And that's wrong. That's refuted later on in this pleading by their own words. But he says he has no knowledge about the gun after it left Italy. Well, now that's probably accurate. But that doesn't mean that his opinion testimony isn't relevant, because he can talk about how the gun works, and specifically about how it doesn't go bang if you don't have the trigger pulled. Nor does he have any information about the functionality of the gun on October 21st, 2021. But he doesn't have to, because he's not there to tell you what happened in New Mexico, because he wasn't there. He's there to tell the jury how the gun was designed, what its safety parameters are, why they're designed the way that they are, and how safe this weapon is if you know what you're doing with it, which is fairly apparent that Alec Baldwin didn't actually know what he was doing with it. So they describe the firearm and they say, as the court is aware, the condition of the revolver on October 21st, 2021, and whether it was capable of an accidental discharge on that date are both highly contested. Well, they are contested, but they're contested specifically for the purpose of confusing the jury. And here's why. Even if the gun had been modified, even if the gun was broken such that it would fire without having the trigger pulled, which we know from the FBI analysis that that's not the case, it doesn't matter if you don't point the weapon directly at a human being. The rules of gun safety say you don't ever do that. You never point a firearm at anything you do not wish to destroy. And Baldwin should have known that, because he has told many people what an expert he is in the area of firearms. but apparently his expertise did not extend to pulling the trigger, I guess. So they say on here that he doesn't know whether it was capable of an accidental discharge on that date. And that's probably accurate. But where they go next is just, it goes into the area of mendacity. Because here's what they say. However, as detailed extensively in Baldwin's prior motions, the firearm was submitted for destructive testing. Well, that is incorrect. The FBI agent who testified this, or the FBI scientist who testified in the Hannah Gutierrez trial, specifically said, no, he didn't go in there to destroy the gun, but when he hammered the hammer, which is one of the tests that you do on a single action firearm to see if those things work, when he did that, the thing broke, and that's just the way it was. But it wasn't submitted for destructive testing. It was submitted for testing. In the process of that testing, it was destroyed, or that those pieces were destroyed. But then the FBI put it back together in a repaired condition. Again, that's a little suspicious. It's a little skeevy to me that they would do that, say it was submitted for destructive testing. I think it would have been far more honest to say it was submitted for testing and was accidentally destroyed. But of course, what they want to do is they want to make that a reason why the court should dismiss the charges, and that's not going to happen. My old boss, who was a Chief Justice of the Missouri Supreme Court, always told me that the one thing you want to do when you are addressing a court is get caught telling the truth 3 times. And once you get caught telling the truth 3 times, you're golden. They're going to believe what you have to tell them. They may not agree with it, but they're going to believe it. And here, when you do something like this and you say it was submitted for destructive testing, and it's not the case, it damages your credibility. And they should know that. But again, they're used to getting by with this kind of malarkey when they do it in a civil case. And they're also not used to being called out on it, but Carrie Morrissey is going to call them out on it. I haven't seen her response to this motion yet, but you can bet that she's going to address this in her motion, or in her motion response. So it says, presumably the state intends to call Pieta to speculate about the condition of the firearm. That's very clearly not why they're calling Pieta. They're calling Pieta to talk about the design and functionality of the firearm. He claims to have performed functionality testing on the gun before it left Italy, but he did not open it up to inspect the internal components. Well, why would you? It's produced in a factory. All of the components are pretty much looking the same. And again, he knows how it's designed and how it functions normally. And I would point out that Baldwin used it multiple times before this incident, because we have that video of him coming out of the cabin and shooting several times.
Set, ready, and action. One more. I forgot the recoil stuff. No, right away. Let's reload. Here we go. So, Helena. Hi.
He used it, and he knows the functionality of the firearm. So they go on to say that Pieta has not seen photographs of the internal components of the gun until his pretrial interview. When shown photographs of various Pieta hammers compared to the hammer from the firearm used on the set of Rust, Pieta stated that the other hammers were from standard production, but the shiny one from the gun used on the set of Rust has something missing in the firing notch or firing position. And of course, that's accurate, because when it was hammered and it was broken, that little something would be missing, because they had to hammer it in order to get it to fire. Because as the FBI expert testified, it wouldn't fire in the half cock or full cock position unless you pulled the trigger. And then they go on to about Pieta has no familiarity with how the parts were broken, insisted there was no way to tell if someone modified those parts. He asserted that his company would not have produced a broken hammer and that the broken parts shown in the picture were not shipped by the company in that condition, which is exactly what you would expect. And then they start conflating his expert opinions on the functionality to him testifying about what went on the set, and that's clearly not why he's being called. Pieta stated he has no opinions about the function of the gun on October 21st because, in his words, I wasn't there. Well, of course not. He was in Italy, and you wouldn't call him for that. So they make the argument and they talk about the 3 prerequisites for admission of expert testimony. Experts must be qualified, their testimony must assist the trier of fact, and the testimony must be limited to the area of scientific, technical, or other specialized knowledge in which they're qualified. And they show that State versus Torres picks up the rules from Daubert versus Merrill Dow, the Supreme Court case. The third condition requires the proponent of expert testimony to show the expert's opinion has a reliable basis in knowledge and experience of his discipline. Well, the guy who designed the gun, you think he's not qualified? Were you dropped on your head at birth or what? Expert testimony may be received if and only if the expert possesses such facts as would enable him to express a reasonably accurate conclusion as distinguished from mere conjecture. Well, he's not going to conjecture about what happened in New Mexico. What he's going to say, and it's fact, is how the gun was designed and what its safety parameters are. So the state should not be permitted to proffer Pieta as an expert in the functionality of the gun on October 21st. And that's not why they're calling him. If Pieta is called to testify, his opinions must be narrowly limited. He stated that he can't give an opinion on anything beyond the point where it left Italy, particularly with respect to the gun's condition on October 21, because he wasn't there. See how they keep repeating that? They go on to say, on any subject other than the condition of the gun before it left Italy, Pieta admittedly lacks the knowledge that would enable him to express a reasonably accurate conclusion. Well, again, he's not speculating or offering opinion on how the gun performed in New Mexico. He's talking about something completely different. And so the goal here is to confuse the trial judge and get her to grant a Daubert motion that essentially either suppresses all of his opinions or, in the alternative, limits them so much that they're not helpful to the state. We'll see how this works for them after the court hears argument on this. Because a lot of times, this judge in particular doesn't really appreciate nonsense, it doesn't look to me like. And so when somebody offers up a specious argument, she's like, I don't think so. So it'll be interesting to see what happens. And, of course, we'll try and follow that and let you know. I think they're holding the hearings on this on July 8th, and I'm looking forward to being able to offer whatever opinions I can at that time. Yeah, that's what I have for you today. If you have any questions, feel free to leave them in the comments down below, or you can email me at the address above. That's perfectly appropriate too. I appreciate all the comments I get, even the ones that are critical. And, you know, frankly, I appreciate the guy pointing out that there was information there on that sheet that I posted in the last video that they did do white-collar criminal defense, although, as I said, there's a big difference between that and this kind of case. If you have the opportunity today, please do something kind for someone. Go out of your way, open a door, do something nice. It makes people feel better, it makes you feel better, and it makes the world a better place. So again, thanks for being here. Come on back tomorrow, catch me down here at the beach, and we'll talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.